and then the second tier being from X number of acres to Y number of acres. Whatever Y is, there be outdoor permitted also, or outdoor permitted as well as indoor. Okay, so if you live on, what, 5, 10, 15, whatever you establish as that kind of middle range, indoor and outdoor, cultivation being permitted with limits that you establish if you choose to. And then the third tier being from Y number of acres, anything larger, indoor and outdoor. So again, my question to you is do you want to adopt a one-size-fits-all for every parcel in the county? Where a person in Lake Forest is permitted to grow as many as a person in Litchfield, 99? Or do you want to adopt the tiered system in whatever form you express it to deal with those densely populated areas while at the same time allowing people that hold parcels in some of the more remote parts of the county with bigger parcels where if they've got a 20-acre parcel or whatever it be, that they be permitted to grow some outside, but that maybe setbacks also, like was discussed last week, in that set of parcels between, not 0 to X acres, because that would not permit outdoor cultivation, but from X to Y acres, if you're going to grow in that zone and whatever number of plants you permit, that there be a setback requirement that accommodates kind of that range of size of parcels. And then from Y on, that there be a greater setback because you've got more dirt to work with.
Okay.
That's balance.
Yeah, and I like that. I don't have an issue with it. What I want to accomplish is, number one, in the residential area, like Lake Forest, whatever, if you have a card that for your own use, you can only grow 6 plants.
0 through 5 acres.
No, I'm just saying the residential area.
Well,
Wait a minute, I'm not done. And just to get rid of what's going on in Lake Forest. That's why we're here today, because of the issue in Lake Forest.
Indoors or outdoors? Or both?
Outdoors. I don't want a person looking over this fence and seeing more than 6 plants.
Okay, and so what I'm proposing to you, Mr. Kyle, is that in that first tier of parcels from 0 to, let's say, 5 acres, you not be permitted, and again, it's your prerogative. I'm just suggesting that if you want to eliminate any of the outdoor growing in some of these really densely populated, you can say, you have every right on the law to say, there'll be no outdoor grows in those really densely populated areas, but you can grow inside.
We can do that. But I just want to get away from the 99 plants in the residential area.
Yeah.
Okay, now in doing that, I see no reason to hurt the legitimate caregiver that is growing for other people. And so how do I fix that? What I would say is you can grow up to 80 plants as long as you got all the qualifications, all the, you've met all the needs, all the licensing and all that. You can grow up to 80 plants, but you must be within 2,000 feet of the residence.
You mean within 2,000 or beyond 2,000?
Beyond 2,000 feet of the residence.
That's almost half a mile.
Yeah, that's almost half a mile. Exactly.
Okay.
You did it in your map.
You mean the residence where the person who's grown lives, or any others?
The person that's growing up to 80 plants, for a caregiver. I don't want a resident to be within 2,000 feet of that person.
But their residence could be.
Yeah, they want to live next to it, it's fine, but anybody else
Oh,
is not.
yeah, I own the property.
Okay.
Yeah, not the owner, not the residence of the owner, no. And we can fix that on the 2-way too. I mean, that could be the last one, 2 or 3.
Okay.
My opinion is 10 acres and less indoors,
0 to 10.
0 to 10 indoors, 10 to 40, 6 plants, and then 40 plus acres would be 80. And then have neighbor consent forms
Yes, sir.
on the,
And we've spoken of that, haven't we?
yeah,
Yeah.
from the 10 to 40s and the 40 pluses on all properties adjoining that abut that property. They'd have to go to their neighbors and get a form, supplied by us that says, hey,
Neighbor got to sign off, says
neighbor's
it's
got to
okay.
sign off on it, it's okay.
But with that, you can still have depending on where the residence is on the 40 acres, it could be right across the street.
We should stick with that 1,000-foot thing, just like with the schools.
Well,
And it doesn't have to be 2,000 feet. I mean, I threw that number out there and discussing this with a person that,
So, if there's support on the board from this kind of tiered approach to growing marijuana, perhaps we could, just by way of a method to get consensus on what that 0 to X number is, and the X to Y number, and the Y to whatever, if that's the consensus of the board, perhaps we could visit what those X and Y values are, and then maybe come back after we work on that and talk about any setback numbers. Let's bite this off in small bites if we can, and then narrow in on it if possible.
and I'll call you in a minute about that.
You know, one thing I think we're kind of overlooking here, and I would like to get to that point, you know, we're talking about cultivation and usage and et cetera. We've heard from the users and we've heard from the growers, but the one thing we're kind of leaving out that we haven't heard from yet, we'd like to hear from, is the definition of the enforcing officers. And we have Dean and Melody and Maury here who are going to be the enforcing officers. And I would like some of their input before we get too far down the road like the beaten path. Get their input.
Before you can do that, I have a question that kind of ties into that, and the problem doesn't want to respond. And I'm looking on page 10. This is under X.21.17, administrative civil penalties, and you use the term administrative penalty.
Sorry, page 10.
Yeah, page 10. And I realize that you're looking at a kind of like an administrative process that kind of parallels, I guess, the legal process.
Yes.
But I look at the structure of things, of felonies, misdemeanors, and infractions is kind of what we have out there on the criminal side of this. So if you get a citation, depending upon the severity of the infraction or the
Misdemeanor.
violation, you'll be, a felony is pretty serious, and that will include jail time, and if you have a record that follows you for the rest of your life, and, there's all kinds of consequences. It's worse than playing monopoly, going to jail, and not passing, going to not collecting the $200. But the misdemeanors are kind of, they're serious, but they're not quite to the level in which the felonies are, and so the consequences of what follows you in life in particular is less demanding, but it's still there in some cases. And of course, an infraction is a slap on the hand, and you pay your traffic ticket or whatever, but it's not usually a violation that causes life-altering consequences. And I'm thinking about people who go to work at a place like the prison or a lot of agencies. If you've got certain convictions or things on your records, you're basically, forget it, you're out of luck. So in the hierarchy of that structure we've been used to, where does the administrative penalty fall in?
That's a great question.
Is it, I mean, it obviously it's an animal separate from the three of those. But how does that, I mean, are there long-term consequences, or if you have enough administrative penalties that pile up because it's a different animal? Is it generating, morph into being a misdemeanor or a felony? How does that work?
So first of all,
And then when we get done answering that question, hopefully the people who are sitting out there, who are the enforcers, can give the feedback that Aaron's asking for, because I think that's a good question.
and by the way, at page 10 in paren A there, line 2 of that, I hope it's not lost on you that there's $3 signs and in parentheses United States American dollars.
So that's what zeroed me in.
Yeah. The 250 to 500 was a number that this board gave me direction to insert in that box, because that had been X's, essentially. It was what do you want that to be an expression of? By law, you may not exceed 1,000. But the language of the draft ordinance is that it would be up to and including the number that you establish. And ultimately, the function of the enforcing officer to prescribe a proposed penalty up to and including $1,000 for an alleged violation, and incumbent on the hearing officer to sustain or not in the amount that's being proposed. And so where does, in specific response to your question, where do you build a record? Do you get a record? Does an administrative finding of having violated the Lassen County marijuana cultivation ordinance appear on your rap sheet? No. Do you get asked about it when you're applying for a job? No. Actually, they can't ask you in California when you're applying for a job anymore about your, it's the ban the box legislation that went into effect, I want to say a year or two ago, where even individuals that are convicted of, I think, felonies are not obliged to disclose that in the employment process. And so, that's California. So I don't think, maybe I suppose if someone was applying for a peace officer position and they were undergoing a comprehensive background check, they might get asked that. I don't know what the specific questions are that are asked, but they might get asked something about, have you ever been found in violation of an administrative rule or regulation? I don't know the answer to that, but then I suppose it could pop up if that were the case, but certainly doesn't get a rap sheet. Did I answer your question, sir?
Yeah, it does.
Okay.
Does any of the law enforcement have any comments?
So before we go to them, let me start by saying I met with Maury on...
Whatever we do want to give Maury and Melanie a badge that allows them to do attendance, which they might be able to function in the administrative part.
She may not even know that she's listed in here. Okay, thank you. But the reason she's listed in here is because it was contemplated, and it's also included in some of the other ordinances that have actually been adopted, Tehama, Sierra, the like, I'm not thinking Melanie Brawley's out there with, binoculars and a little ticket book, hiding behind a tree like the assessor trying to scratch people from, growing too much, if that's the perception. It's that the health officer is perhaps a person that might encounter a grow in their normal duties and could become an enforcing officer within the meaning of the ordinance. But certainly, planning a building or building and planning, I never get it right, would have code enforcement folks that might become designated, and certainly deputy sheriffs would encounter folks that might be in violation. So that's who the enforcing officers are contemplated to be.
Okay, with that. If not, I got a couple of people want to speak. Maury, you got something to say?
Yeah, I just thank you, Aaron, for asking one of the three enforcement officers to speak on it. And I appreciate the ordinance, the way it's drafted right now. I think a lot of time and effort went into it. And when I first read it, I don't think I wrapped my head around it. I read it 20 times now, and every time I would try to come up with an issue or a problem, I find that it's been addressed in some way or form in the ordinance. So I think it's a well-written ordinance. In the last couple of board meetings, we've gone from the one size fits all to potentially a sliding scale, and that if that's the board's pleasure, then we have to figure it out. We're here to serve the board, but it does, I think, make it a more complicated ordinance, and there's issues that are, of course, going to come up with anything that we approve, and that's okay because it's dynamic. We're here a few years later after the first one, and tweaking it and trying to get it right and trying to strike that compromise. But as usual, the bureaucrat says, I'm just worried about when you say our code folks, plural, and it's one, and we can't do what we're supposed to be doing right now. I mean, we're drinking out of a fire hose just with our normal code enforcement issues. So, I think it would be prudent to contemplate what it means from a fiscal standpoint when we make these decisions and who's doing what. And right now, the way it's written, with the three of us being the enforcement officer, I'm sure there's going to be a lot of this, and it's going to be contingent on who's got people and who's got the time, and those don't always sound good when there's issues, and things need to be addressed. And so I I guess I'm here to say we're going to, of course, deal with the board, decides it's the best balance. But think about some of the ramifications. If you're saying 80 plants, if you're over 40 acres, somebody complains, how do we get a check? We got to go get a warrant? I mean, there's a lot of unanswered questions in my mind on how the mechanics will work. Not to say they can't, but, we're going to be stuck to figuring it out after the decision's made. So, just food for thought.
Good, no.
When I look at this, the thing that occurred to me is that, I do have environmental staff who are out in the field pretty regularly, and I also have child welfare and protective services staff who are out in the field. And so they may come across a grow like this. I saw this primarily as being probably a place people would call to report such a grow because of their own health concerns. And in my mind, I was going to approach it like an abatement issue like we already do with the sheriff's office and planning and building. But Maury's absolutely right. There's a lot of time and effort that goes into those processes. So just something for you to think about.
I have a question on that. These guys would be like enforcement officers.
This is a great discussion.
That's different from an administrative hearing officer.
Yes.
A hearing officer, when I read that, they're talking about appointing an attorney of law.
It's required by the code.
Required, okay. So,
More than 5 years.
because I kind of have concern about staff being the ones that are resolving the administrative.
They shouldn't be.
Okay.
It should be an independent body.
For a while there, I
Provides,
was
as I
thinking
said,
it was all coming together
No.
in one. I'm going like, I let Bill too much to give her that duty. So
for it to have any credibility with the folks who are the subject of it, I think that
it has to be independent.
it has to be independent.
The courts have, you have your judges and then they have.
Commissioners?
Yeah, commissioners,
It's
they kind of
similar.
handle stuff on the side.
Yes, sir.
Similar to a commissioner.
Yes.
Okay. That helps.
Yes.
Sure.
All right, so I did meet with the county council on this. Our primary, obviously, like Bill mentioned, we get called all the time about marijuana grows. Whatever ordinance is adopted, our guys are going to be getting called and going to those properties to check them. What I want to be able to do is have our guys have some kind of clear form that shows restrictions, so they can tell the citizen what they need to do to come into compliance. That's going to be our primary goal. It's educating them, showing them what the local ordinance is, showing them how they can come into compliance. And then if they don't, then that's the big question, is who's going to be responsible for that next step once some action needs to be taken. So my first concern, again, like I've mentioned each time, is that it's clear, it's easy to understand for the citizens and my people that are going to be going out there and looking at these properties. And we still have to clarify, who's going to be responsible for taking the next step once enforcement needs to occur. Obviously, if it's a state law violation, we'll be investigating it. But if it's not, if it's a violation of ordinance, we'll have to make that determination who's going to do what.
If I can speak to that for just a moment. I appreciate learning from the Tehama experience and the Sierra experience and other counties' experience. The enforcement officer was initially any person in the category or that fits within the definition. What they had done was, any deputy sheriff or any code enforcement officer out in the field, they had a kind of group training in their county. And if a grow was detected in violation of the ordinance, those individuals were then authorized to issue this thing called a notice of abatement. And it set forth, the names of the parties who owned the parcel, all of the things required in the contents of notice section in this ordinance. And then it would be served on those folks, and then they could make a request for a hearing. The problem turned out to be that probably as was reported to me, 60 to 70% of those initial efforts to abate what was detected to be, grows in violation of the ordinance, either the parcel wasn't described right, the proper people weren't identified, the correct condition that was alleged to be in violation wasn't identified right, and they were garbage. They were essentially no-goes from the beginning. And all this time had lapsed. Meanwhile, everything's grown. Meanwhile, people are offended. Sensibilities, nuisance, all of that, whatever. And so what happened was they learned from that. And what they learned from that was to rein it in, to pull it in-house, to have a kind of central clearinghouse, if you will. One designated person within the county that was essentially the contact point or the enforcing officer, if you will. So if a deputy sheriff is out in the field, deputy sheriff is in Little Valley, just pulling a community out of my ear here, and they see it grow, and it is detected that it perhaps is in violation of the ordinance, that deputy has been trained to reach out to that contact point in the county department. In Tehama, it's in the environmental health department. All right? In most other counties, it's in the equivalent of planning and building services. And that person in that department is charged with receiving essentially a little one-page narrative report from the deputy sheriff or the code enforcement officer or the environmental health officer, or whatever the case may be, identifying the address, who they contacted. That enforcing officer finds the APN, who the correct owner of record is, making every effort to correctly identify the notice that's then to be served. So it's right from the beginning. And it's served on the right people. And there's a significantly reduced opportunity to derail the enforcement effort from the very beginning. That's how it's contemplated. I hope I answered the question. And you know, I work with Maury every day. I see him all the time. I know they've got staff shortages over there, and I feel bad, but the logical resting place for it is